Immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I also have a great topic for you today, and it's how to apply for permanent residence while being in the United States without the need to leave. Yes, that can be done. Whether you qualify, that's going to be a whole other story. That's where we have to talk in a consultation. But I can certainly tell you different ways that this is possible to apply for permanent residence without the need to leave. So it's not what I like to say. The first thing to know is when you are staying in the United States and you're applying for permanent residence while you're here in the United States, that's called adjustment of status. And while you may be qualified to apply for permanent residence through a petition, it does not mean that you qualify to apply for adjustment of status. Meaning, some people do have to wait outside of the United States for permanent to get the immigrant visa to come here for permanent residence, while some don't have to wait. This is a complicated, it can get complex, and this is where the consultation is required. But I'm going to touch on some major ways that you would be able to stay here in the United States and apply for your green card, especially if you are already here and even if you're already out of status. I know that's a problem that many people have, where you may have already overstayed, or maybe you came into the country without permission, and now you are trying to figure out how is it that you can get your papers straight. I like to say, how can you fix your status, right? Um, and that's possible. So let us talk about that. Now, when it comes on to employment, employers can't help you to fix your status. In the case that you have already overstayed and you've already started working without permission, it is there are very limited options to fix your status at that point. There is one way. That's not really a topic to stay, because it doesn't mean you get to stay here while you apply through the employer. So that's for another day. But when so once you've started working for the employer cannot petition for you through adjustment of status to fix your papers. So if an employer is promising you that if you come and work for them, they can help you to fix your status, or they can give you some kind of work permit, know that that's false, right? They cannot do that for you. Some employers do this on purpose to get you to work for them, and then they get you into a tough situation. Some employers may do it thinking they can and then realize that they can't, and sometimes even mess you up even further, because some employers will say, why don't you overstay and I'll just get you your work permit. So make sure before you take any action, you get legal advice. Employment off the table when it comes on to being out of status, right? If you are in status, though, if you're in status, and as long as you haven't started working for the employer, you can still apply for adjustment of status through an employer, as long as your visa is still valid and still current, and you're still within the time you are given permission to be able to apply. And as long as you apply before your time is up, and as long as the employer has filed a petition and gone through all the steps they have to go through, then at that point, adjustment of status is possible. So if you're out of status, an employer can't help you at that point to fix it. If you're in status and the employer took all the steps they need to take, file the petition for you, maybe file a labor certification for you, your visa hasn't expired and you haven't overstayed the time you were given, then at that point, you could then possibly apply for adjustment of status. But once again, make sure you get legal advice before you explore that option, any option in regards to immigration. Now, you're out of status here, right? How can you fix that situation to stay here and get the green card? So the first is through family, and there are limited categories of individuals, or a limited category that allows an immigrant who has overstayed their visa, not entered the country without permission, only overstayed their visa, came in legally, overstayed their visa, to apply for adjustment of status. So even if they overstay their time, they can still move forward with the process. The people who can apply for this will be the spouse of a US citizen, only a US citizen, not a permanent resident, only a US citizen, the parent of a US citizen, not just any US citizen, the parent of a US citizen, and that US citizen is age 21 and up, and that citizen petitions for them. Or if you are the son or daughter of a US citizen and you're under 21 and unmarried. If you have reached the age of 21, at that point it's too late. If your parent has not filed the petition before you turn 21, then it is too late at that point, and you've gone into the 5 to 7 year category where it takes 5 to 7 years, and you're not allowed to stay in the US and apply for green card at that point. But if you are under 21 and unmarried, then of a US citizen, not a legal permanent resident, you're able to still move forward with adjustment of status while being here. So that's based on family, and that's one way you could fix your status. But what if that option, what if you do have those family members or that spouse, but you don't have the option of them filing for you? So in this case, there is the broader option of VAWA, where you can stay here and you can apply. And you can apply if you came into the country without permission, whether you overstayed your visa. Even if you're here on your current visa, you could apply for this, for VAWA. If you have a US citizen or a legal permanent resident, spouse, a parent, or a citizen son or daughter who's age 21 and up, right? So in this case, under the VAWA category, if you have a permanent resident spouse as well as a citizen, a permanent resident parent as well as a citizen, or a citizen's son or daughter who's age 21 and up, and those relatives mistreated you. Maybe that's why you don't have the option of applying through them, because they mistreated you. Then at that point, you do have the flexibility to apply for special VAWA status. And once that VAWA status is approved, or at the same time, you can apply for your work permit and your permanent residence. So then this category is an important form of relief for people. Many people who you have this relationship, but you don't have the option of them applying for you because they may be mistreating you. And a part of that mistreatment is that they won't submit the paperwork. And so you need to know that you can apply on your own. You do not need this relative who is mistreating you to be able to submit this application. And in this case, you don't have to have status. You don't have to even, in some cases, show legal entry into the United States. And there is forgiveness for past immigration violations. So at the same time, we can request that you get forgiveness for certain past immigration and even criminal violations. So if you have, say you came into the country and you came in with someone else's papers, there still is the opportunity to apply for a special waiver to get forgiveness. If you lied to get into the country or lied to get a visa to come, that can be forgiven as well. And we do submit all of this at the same time. We submit the VAWA, adjustment of status, work permit application, travel document application, as well as an application for forgiveness. It's called a waiver, right? So that is one way. And now, what if the relative has passed away? What if they were deported? You can still apply for this relief as long as you apply. As long as you apply under 2 years after the death happened or the deportation. If, say, a U.S. permanent resident got deported because maybe they got domestic violence, maybe they abused you, maybe it was for something else, but they were mistreating you, they got deported. As long as you apply within 2 years of the deportation, you can still qualify for this type of relief. So it's a very, very important form of relief that allows you to stay here and apply for permanent residence. So if you experience in any way any mistreatment by a U.S. citizen or legal permanent resident spouse, a parent, or a citizen son or daughter who is age 21 and up, this could be for you. But I want to go back to, what if your parent mistreated you, but now you're over 21, right? Say you're 21 or over. Is there any way you could still get relief through VAWA? Yes. If you're, as long as you have not reached the age of 25, you can still possibly qualify for VAWA relief if the reason you didn't apply for VAWA was because in related to the mistreatment. So for example, if you were within the control of the parent who was mistreating you and you didn't get to escape until you were 24, or you didn't get out of the situation until you were 24, then you still have a chance at applying for relief through VAWA. So under certain circumstances, in regards to a U.S. citizen or legal permanent resident parent mistreating you, you can still apply for this relief up to the age of 25. So keep that in mind. Go ahead, call the office. The link is in the profile to see everything you need. There's the website where you'll see the phone number, the contact form. You'll also see the online chat right now during office hours, which is 9:30 to 6:30. But there's the phone lines that are 24 hours. Then you can also go ahead and call the number. It's in the description of this video. It's on the video. It's on all of my videos. You can call to speak directly to a scheduling coordinator. You can also schedule your own appointments. It's really convenient, really easy to do that, and you'll be set once you get on my schedule. Now, let's talk about some other alternative options here. So I talked about VAWA, but there are others that people don't necessarily know about. So there is also what's called the T status. In the case that if you had an intimate partner who withheld your paperwork, kept you here, made you do work in their home, made you take care of children, made you work in their business, made you work in their house. If you had a past employer who promised you that they'll get you your papers and then you ended up in a situation you really did not want to be in, you were not willing to be in that situation. Had it not been for the fraud, you would not have been in that situation. This could qualify you for T status, right? T status is for victims of trafficking, but trafficking comes in different forms. And it's not just a situation where someone is tied up somewhere and forced into doing sex acts. That does count. That does happen. But it's not just that. It's in regards to the employment situation. It's in regards to having an intimate partner. So say the intimate partner isn't a U.S. citizen or a legal permanent resident. Say they themselves were undocumented and they put you through this abuse and manipulation and control, and they made you do things against your will that you really didn't want to do, but you felt you had to do. Then you could qualify for this. If it could be anybody who did the victimizing. It doesn't have to be a U.S. citizen or legal permanent resident. Thank you for the love, by the way. So it comes in different forms in the sex context. In the case of an intimate partner where they've subjected you to not only domestic violence but forcing you to do acts against your will, acts you wouldn't do if it was up to you, then this is a form of sex trafficking. And if you were in a situation where an employer kept you stuck under their control, if an employer ever threatened to call ICE on you, if your intimate partner ever did that, you could qualify for relief here. Now, the intimate partner does not have to be your spouse. It could be as someone, when I say, that's why I say intimate partner, because it covers all sorts of different situations. And some of you that may not have been in a situation like this may be thinking, how could a trafficker be an intimate partner? And believe it or not, this is sometimes how a trafficking situation starts. Is they at first they start out sweet. They lure you with promises. They take care of you. They do everything for you. If you're in another country, they get you here first, and then that's when things start to change, when they get you within their control. And then once they get you here, that's when they start to do things like force you to take care of their kids, force you to take care of the house, maybe force you to do acts with other people or with them, just to have you there for their own purpose against your will. That's how this happens. It starts with intimate partners, and even the policy manual at the USCIS addresses these issues, because the USCIS, as the immigration service, recognizes that these things happen in trafficking situations, and they have instructed their officers to consider situations like this to be able to provide the trafficking victims of trafficking status. The status does allow you to get your work permit for 4 years. It allows your children, whether your children are in or out of the US, to be able to get this, your spouse to get this as well. Now, this is a non-immigrant status, right? But it does offer a path to permanent residence. So once you're approved as for T status as a victim of trafficking, we then get started on applying for our clients' permanent residence, and they get to stay in the United States and do it through adjustment of status. And so that's why I'm mentioning it here. So this is a two-step process, but it's an eventual path to gaining permanent residence. The first step is to get the T status, which we do for our clients. And then the next step is to apply for adjustment of status once they've been approved. And that is a whole step that we manage everything for our clients to be able to get them adjustment of status, the permanent residence through adjustment of status. And it's possible to get adjustment of status earlier than 3 years. So generally, you have to have it for 3 years before you can become a permanent resident. But under certain circumstances, if you take certain steps, you get to do an early adjustment of status. And so that's one thing we do help our clients to do. So that is also an important form of relief that can serve as an alternative to VAWA in the case that an intimate partner subjected you to do things for them that you really didn't want to do. Then there's asylum. If you are applying for asylum and you do get asylum, a year after having asylum, you can then adjust status in the United States without the need to leave. So you want to know more about the T status. So go ahead, give the office a call. I did state a majority of the details here about the T status. So go ahead and give us a call. The T status is an important form of relief for undocumented immigrants. You don't need to have status to get this form of relief, and your relatives, your parents, if you're under 21, your parents, your sibling under 18 and unmarried, your spouse and your children can get this. If you're 21 and over, your spouse and your children under 21 and unmarried can get this relief along with you. And they don't need to be victims. They just need to have that qualifying relationship with you. With asylum now, if you are afraid to return to your home country, you need to apply. So you're afraid to return to your home country because you're being persecuted. Not Now, asylum does not count if, say, you can't find a job in your home. I mean, in your home country. If you can't find a job, say because you're being persecuted, they're severely restricting your ways to survive economically because of who you are, then that's a different story. But basically, with asylum, you should apply if you're afraid to return to your country because you're being targeted based on your political opinion, based on your ethnicity, your race, your religion, based on any particular social group. And any particular social group means that if you're a part of any kind of group and you're being targeted, usually the characteristics of this group has to be unchanging. So this has to be unchanging. Um, uh, uh, just let me know if you can hear me. Let me know if there's any sound. I'm going to scroll down. I'm hoping there's sound. Go ahead and let me know if you can hear me. Okay. All right. So I need one more. I'm hearing. Okay, hearing now. Awesome. Perfect. Okay. Thank you so much. I'm glad. Okay, good. All right. So with asylum, once I identify that you qualify, we get on it right away. Now, it's important to understand there's a deadline for this. If you do not apply on time, so you need to apply within 365 days from the date of your entry into the United States. If you don't, then it's going to be a lot harder to show that you qualify for asylum. So when you go ahead, if you are already in the United States and you want to make sure that you have the protection of asylum, go ahead, give us a call. Now, I'm going to give you some examples of situations where you may qualify for asylum. So now, if you are being subjected to domestic violence and domestic violence is prevalent in your country to the point that you cannot get any protection because it's basically something that's so pervasive that is accepted in your country. And if you will surely face harm and death from your spouse. Police aren't doing anything, government aren't doing anything for you, then this could qualify you. Another is if you are being targeted by gangs or you're being targeted based on your political affiliation. So if you are a part of if you have shown support for a political party, or maybe you haven't shown support for a party and now you're being persecuted or harmed because of that. Maybe in your community, if a majority of people are a certain party and you're not, and now you're facing danger. These could be persecution based on your political opinion. Um, if you're being targeted in other ways, so maybe if you're facing some sort of gender-based violence, if you are facing any violence or harm or threats based on your sexual orientation or the way you identify, the gender you identify with, then that can qualify you for asylum in the United States. So go ahead, give us a call. We can evaluate your situation and determine whether you qualify. The reason I'm raising this though with asylum is it can allow you to adjust status here in the United States, to be able to stay without ever leaving. So I just listed a number of options that are available if you're already out of status. Now, if you are in status and you qualify through a family member, you have to meet certain conditions, but you are in a better position to adjust status. So for example, say you're visiting here and say you're visiting so right now, for example, you're visiting your permanent resident spouse. Right now, priority date is current for spouses of permanent residents. So it's current. Now you're here on a visa. You haven't overstayed. At that point, you can submit your adjustment of status as long as you haven't overstayed and you apply before the permitted time. So in that case, you're good right there. Always, though, seek legal advice and representation to take these steps because they can get very tricky. The same for if you're 21 and over and you have a parent here, and say the parent petitioned you years ago, and now it's time, and your date is now current, you're here with legal status, then at that point you are in a good position to apply for adjustment of status. You just have to make sure you don't make the mistake of submitting it after your time is up here on the visa. So, what I talked about to you were options in regards to staying in the US if you're already here and you're out of status, right? You've already overstayed and you're trying to figure out how can you fix this situation. So I just listed some ways through T status, through VAWA, through asylum, that these options may be available to you in the future. All right, so go ahead, give us a call and we can evaluate your situation. And should you qualify, we'll get started and get your petition in ASAP, because that's what we do. We do help clients to get out of a sticky situation, especially when they're out of status. The great benefit of adjustment of status, where you get to stay here and apply, is you do get to get your work permit and your travel document while you wait for your process to be completed. All right, so I'm going to go to questions. I see some here. So if an immigration lawyer charges you for a service and does not provide such service, what's next? So, that really is not, it's not a question I would be able to answer, just because that would have to be between you and the attorney. What are the stages for EB2 green card for countries like Saudi Arabia? So first, the employer has to petition for you. In regards to the EB2, if you're talking about the national interest waiver, then you could explore whether you do qualify to apply on your own. But usually you do have to apply through the employer. The employer has to get labor certification. Once a petition is approved, if you're outside of the US, you will go to the embassy for an interview. If you're in the US and you qualify, you apply for adjustment of status. So in regards to Saudi Arabia, the EB2, whether your priority date is going to be dependent on the chart and the date that you file the petition. So all right, so I'm going to go through and continue to answer questions. Just be patient with me, please, as I just go through and find your questions. So I saw here on YouTube, how long does it take for work permit with T visa? And if at the time we apply for T status, at that time, if your kids are under 21, they're covered? Yes, absolutely. So children under 21 and unmarried are covered, as in they do get to apply as derivatives, as the dependents. And then for once it's approved, and right now it's taking on average about 10 months, 9 to 10 months to get the decision, but it can take as long as a year and a half, just depending on the complexity and whether the immigration service has more questions. Thanks so much for the compliment, Sheldon. If someone's mother started the filing for them and the mother dies within the process, can the process still be completed? Yes, there is a way to ask for humanitarian reinstatement. This is on a case-by-case basis. So you would need to, that person needs to have an appointment to discuss exactly what happened in order to see if they qualify for that humanitarian reinstatement. But it is possible to do it if they qualify. All right, I'm just going through quickly. I have a question about the I-485, the public charge section. Should I include debts owed in Jamaica or only debts accrued in America? So make sure that you get assistance to complete this, because the public charge section only applies to certain individuals if the public charge if you're subject to public charge, you really do need to have knowledge about the new policies and the new rules. So make sure you get help with that. I can't advise on what you need to put in the form, what you don't need to put in the form, because that's too specific. So, make sure you get representation, because once you're not sure, you need to make sure you protect yourself and get the assistance and representation you need. Now, one thing I do want to mention is that when it comes down to the public charge, they're not necessarily looking at debts, right? So the public charge rule does not include debts. I think you may still be thinking at the old policy during the Trump administration when they were asking you to list. They had a special form you had to complete to, you had to disclose your credit score, you had to disclose all your debts that you had, your education level, and all of this. This is no longer relevant. So, make sure you understand, or you get an attorney who understands how to approach this, because you could actually be making your situation worse. Thanks so much, Bobrisky. I am. Thank you. I hope you're having a great day as well. If someone got their citizenship but owes child support and wants to travel internationally, would there be an issue for them to return to the US? They didn't get their US passport. So, as a US citizen, you must enter with a passport. So you don't want to be taking that risk, right? So usually, if you owe child support as a US citizen, they do reserve the right to not provide the passport, to deny the passport. And so you could be running into a lot of complications if you leave the country without your passport and you're trying to get back in. Furthermore, delinquent child support is something that they can actually deny citizenship for. So you want to be careful. You don't ever want to run into problems where now they're reopening your citizenship, because they now feel like you have child support. Was this child support delinquent before you got the citizenship? So, at this point, this person needs to deal with their child support issues and get the passport before they travel internationally. Thanks so much. And also, since Sheldon is saying here, people watching, please like the video. That's exactly. I often get so caught up in this conversation that I don't usually say, make sure you share, make sure you like, follow, subscribe, because it does help other people to get good information that empowers them. It educates them about the process, and it helps them to understand that, whether they need help or what direction they need to be going through. And a lot of people here on this platform have, like a lot of my clients, have now learned that they do qualify for immigration relief, and that really has changed their lives. So, go ahead and share, like, follow, subscribe. All right. Do your spouse have to leave the US for consular processing if you file AOS as an LPR? So, great question. If you are a legal permanent resident, your spouse was here at the time they applied for adjustment of status, they had legal status, as in they did not overstay the time that the officer gave them when they came in, then at that point they may be safe. It's Now, this is general information. I don't know what your that situation is, so that's where getting representation is going to be very important. But usually an LPR, legal permanent resident spouse, can file for adjustment of status as long as that immigrant spouse is not all out of status. All right. Okay, and thanks for the love. I appreciate it. If you overstay your visitor's visa, there is any way you can get your stay without marriage. So it is possible. I did talk about some of those ways today, through the T status, through asylum. It depends on how long you overstay, though, through other relatives, through so it's good, and through other relatives under VAWA. If say you were married, now you have an ex, and that ex mistreated you, and it's less than 2 years since the divorce, then you could possibly qualify in those ways. But you're never really going to know your options unless you talk to schedule a consultation with an attorney that can give you all the options. How long after you submit adjustment of status do you receive the receipt of acceptance? So it goes anywhere from 2 to 4 weeks afterwards. What does priority date signify? So it's basically the date that they're going to be able to issue an immigrant visa number. So that's as simple as I can put it. There's a special chart that you can check where they are processing, because the priority date is very important when it comes on to determining when you need to submit your adjustment of status application, or when they will start to process you at the embassy in your country. How long does it take for adjustment of status if you're married to a citizen and currently in the US? So I've seen anywhere from 5 months to 5 to 8 months on average, but you could expect anywhere from 5 months to a little over a year. Now, the ones that I see that take the longest are the usually people. Lately post COVID, I've been having really good results with my clients through adjustment of status, and it has been going smoothly and quickly. However, when where I do find a lot of people have bad experiences is where they submit it and they really submit a sloppy application. They don't even know they're submitting a sloppy application until all the complexities start to happen. And so their process drags on for a year and a half to 2 years after the fact. So I've seen that. But I know, a year and a half to 2 years is pushing it for an adjustment of status. So when applying for VAWA, what's the 1225 for? So that is the adjustment of status application. So if you're paying 1225, that's the application fee. Keep in mind it may be going up to 1550. But when you're applying for that under VAWA, it means that you're also applying for your permanent residence at the same time. Uh, when you apply for VAWA, do you get a 2 or 10 year green card? Great question. A 10 year. They skip the 2 year, they jump straight to the 10 year. And guess what? If you are the spouse of a US citizen, you get to apply for citizenship within 3 years of getting that green card. So you get a shorter time to apply for citizenship. So, is it best to file for my mom and sister at the same time, or just my mom, then have her file for her? Great question. So, if you file for your sister, it's going to take 14 years. If your mom, if you're a citizen, of course, you have to be a citizen to file for your mom. Your mom gets it within, could be 6 months to a year. Then your mom files for your sister. If your sister is under 21, she could be here with her permanent residence in 2 years. If she's 21 and over, then about 5 to 7 years. Oh, thanks so much, Rowena. I'm glad that I could provide the information. I do this Monday through Friday at lunchtime, so you can join me on any of those days to ask your questions. Thanks so much for your comment. Can you qualify for 10-year green card if your spouse is a resident? Yes. Yep, you can. But yeah, it's tricky in that you have to be careful about your overstay, your time. So just be very careful and get representation. But a permanent resident can file for their spouse. Permanent resident who files for a spouse who overstays means that they can't do an adjustment of status. There is another type of process that's available, but not adjustment of status if the spouse of a permanent resident overstays. So rule number one, don't overstay. And now is a good time for spouses of permanent residents to apply. Just don't overstay. Get the representation you need to do it right. So parents came illegally. I am citizen. Can I use my grandparents for the waiver if I'm filing for them? So if your grandparents, so in order to qualify for the waiver, you have to have a U.S. citizen or legal permanent resident parent, or a parent or a spouse. So if the grandparents is your parent, so your grandparents is the parents by parents, right? Then, and they're citizens or permanent residents, then yes, it does not have to be just you. And by the way, you wouldn't count as a relative for the waiver because children don't count. So just as long as a grandparent is the parent of your parent who is applying. Say it's an in-law, the grandparent is an in-law, no, it has to be the actual parent of your parent, and that grandparent has to be a permanent resident or a citizen. And once again, before you do anything, make sure you just get representation. That's the best way to go. After the biometrics, is there any way they could deny you in the VAWA process? Now, a denial is always a possibility in the application process. So biometrics does not mean that you're going to necessarily succeed. It means that they're doing a background check. So biometrics does not mean that you have been approved. It's not indicative of a decision. Um, All right, so that is it. I don't see any other questions, and my time is up. I really enjoyed this conversation, so I will be back tomorrow as usual, Mondays through Fridays at around lunchtime. So, afternoon, I am on here. So go ahead and you can ask your questions. So I do see two more questions I'm going to answer. I have a B1, B2 visa. Can I adjust my status? If yes, how long is the process? So just having a visitor's visa alone does not mean that you can adjust status. You have to have other qualifying relatives or an employer or a reason to do that adjustment of status. So we'll have to evaluate all of that in a consultation. What if my mom overstays her visa and I'm a citizen? Can she do adjustment of status? So, what I will say in your case, I don't know with your mom what the situation is. And before you take any action, make sure you get legal advice and representation. But parents of citizens who are age 21 and up can qualify for adjustment of status even after they've overstayed. But if there are other factors involved that can prevent that from happening, that's where the consultation is going to be very important. Go in the description of this video, you're going to see the link to schedule your own consultation. You can do that, or you can call the number, talk to a scheduling coordinator, and they'll be more than happy to go ahead and talk to you about scheduling and actually help you through the scheduling process. So I am going to head out. Thanks so much for a great live today and a good conversation. I'm looking forward to seeing you tomorrow, where I'll come with another topic. You think of your questions. And remember, if you have particular questions about you, about your situation, you're ready to take action and get representation, that's where you call and you do the consultation, and I'll be more than happy to help you. All right. Have a good one. Bye bye.